Hello, everyone. We're going to wrap up Furman v. Georgia. I'm going to do part 3, so starting with Mr. Justice Blackmun dissenting. I join the respective opinions of the Chief Justice, Mr. Justice Powell, and Mr. Justice Rehnquist, and add only the following, somewhat personal comments. 1. Cases such as these provide for me an excruciating agony of the spirit. I yield to no one in the depth of my distaste, antipathy, and indeed abhorrence for the death penalty, with all its aspects of physical distress and fear and of moral judgment exercised by finite minds. That distaste is buttressed by a belief that capital punishment serves no useful purpose that can be demonstrated. For me, it violates childhood's training and life's experiences, and it is not compatible with the philosophical convictions I have been able to develop. It is antagonistic to any sense of reverence for life. Were I a legislature, I would vote against the death penalty for the policy reasons argued by counsel for the respective petitioners and expressed and adopted in the several opinions filed by the justices, who vote to reverse these judgments. 2. Having lived for many years in a state that does not have the death penalty, that effectively abolished it in 1911, and that carried out its last execution on February 13, 1906, capital punishment had never been a part of life for me. In my state, it just did not exist. So far as I can determine, the state, purely from a statistical deterrence point of view, was neither the worse nor the better for its abolition, for, as the concurring opinions observe, the statistics prove little, if anything. But the state and its citizens accepted the fact that the death penalty was not to be in the arsenal of possible punishments for any crime. 3. I, perhaps alone among the present members of the court, am on judicial record as to this. As a member of the United States Court of Appeals, I first struggled silently with the issue of capital punishment in Figure v. United States. The defendant in that case may have been one of the last to be executed under federal auspices. I struggled again with the issue and once more refrained from comment in my writing for an en banc court in Pope v. United States. Vacated upon acknowledgment by the Solicitor General of error revealed by the subsequently decided United States v. Jackson. Finally, in Maxwell v. Bishop, vacated and remanded sua sponte by the court on grounds not raised below. I revealed solitarily and not for the panel my distress and concern. And in Jackson v. Bishop, I had no hesitancy in writing a panel opinion that held use of the strap by trustees upon fellow Arkansas prisoners to be a violation of the Eighth Amendment. That, however, was in prison punishment imposed by inmate Furman. 4. The several concurring opinions acknowledge, as they must, that until today capital punishment was accepted and assumed as not unconstitutional per se under the Eighth Amendment or the 14th Amendment. This is either the flat or the implicit holding of a unanimous court in Wilkerson v. Utah in 1879, of a unanimous court in Kemmler in 1890, of the court in Weems v. United States in 1910. Of all those members of the court, a majority who addressed the issue in Louisiana ex rel. Francis v. Resweber, and of Mr. Chief Justice Warren, speaking for himself and 3 others, Justice Black, Douglas, and Whitaker, in Trop v. Dulles in 1958. In the denial of certiorari in Rudolph v. Alabama, where, however, Justice Douglas, Brennan, and Goldberg would have heard argument with respect to the imposition of the ultimate penalty on a convicted rapist who had neither taken nor endangered human life, and of Mr. Justice Black in Magatha v. California, decided only last term on May 3, 1971. Suddenly, however, the course of decision is now the opposite way, with the court evidently persuaded that somehow the passage of time has taken us to a place of greater maturity and outlook. The argument, plausible and high-sounding as it may be, is not persuasive, for it is only 1 year since Magatha, only 8½ years since Rudolph, 14 years since Trop, and 25 years since Francis, and we have been presented with nothing that demonstrates a significant movement of any kind in these brief periods. The court has just decided that it is time to strike down the death penalty. There would have been as much reason to do this when any of the cited cases were decided, but the court refrained from that action on each of those occasions. The court has recognized, and I certainly subscribe to the proposition, that the Cruel and Unusual Punishments Clause may acquire meaning as public opinion becomes enlightened by a humane justice. And Mr. Chief Justice Warren, for a plurality of the court, referred to the evolving standards of decency that mark the progress of a maturing society. Mr. Jefferson expressed the same thought well. My problem, however, as I have indicated, is the suddenness of the court's perception of progress in the human attitude since decisions of only a short while ago. 5. To reverse the judgments in these cases, is of course the easy choice. It is easier to strike the balance in favor of life and against death. It is comforting to relax in the thoughts, perhaps the rationalizations, that this is the compassionate decision for a maturing society, that this is the moral and the right thing to do, that thereby we convince ourselves that we are moving down the road toward human decency. That we value life even though that life has taken another or others, or has grievously scarred another or others and their families. And that we are less barbaric than we were in 1879, or in 1890, or in 1910, or in 1947, or in 1958, or in 1963, or a year ago in 1971, when Wilkerson, Kemmler, Weems, Francis, Trop, Rudolph, and Magatha were respectively decided. This, for me, is good argument, and it makes some sense. But it is good argument, and it makes sense only in a legislative and executive way, and not as a judicial expedient. As I have said above, were I a legislature, I would do all I could to sponsor and to vote for legislation abolishing the death penalty. And were I the chief executive of a sovereign state, I would be sorely tempted to exercise executive clemency as Governor Rockefeller of Arkansas did recently just before he departed from office. There, on the legislative branch of the state or federal government, and secondarily on the executive branch, is where the authority and responsibility for this kind of action lies. The authority should not be taken over by the judiciary in the modern guise of an Eighth Amendment issue. I do not sit on these cases, however, as a legislature, responsive to, at least in part, to the will of constituents. Our task here, as must so frequently be emphasized and re-emphasized, is to pass upon the constitutionality of legislation that has been enacted and that is challenged. This is the sole task for judges. We should not allow our personal preferences as to the wisdom of legislative and congressional action, or our distaste for such action, to guide our judicial decision in cases such as these. The temptations to cross that policy line are very great. In fact, as today's decision reveals, they are almost irresistible. 6. The court, in my view, is somewhat propelled toward its result by the interim decision of the California Supreme Court, with one justice dissenting that the death penalty is violative of the state's constitution. As far as I am aware, that was the first time the death penalty in its entirety has been nullified by judicial decision. California's moral problem was a profound one, for more prisoners were on death row there than in any other state. California, of course, has the right to construe its constitution as it will. Its construction, however, is hardly a precedent for federal adjudication. 7. I trust the court fully appreciates what it is doing when it decides these cases the way it does today. Not only are the capital punishment laws of 39 states and the District of Columbia struck down, but also all those provisions of the federal statutory structure that permit the death penalty apparently are voided. No longer is capital punishment possible, I suspect, for, among other crimes, treason, or assassination of the president, the vice president, or those who stand elected into those positions, or assassination of a member or member-elect of Congress, or espionage, or rape within the special maritime jurisdiction, or aircraft or motor vehicle destruction where death occurs, or explosives offenses where death results, or train wrecking, or aircraft piracy, and or explosives offenses where death results, and or train wrecking, or aircraft piracy. Also in jeopardy, perhaps, are the death penalty provisions in various articles of the Uniform Code of Military Justice. All these seem now to be discarded without a passing reference to the reasons, or the circumstances that prompted their enactment, some very recent, and their retention in the face of efforts to repeal them. It is of passing interest to note a few voting facts with respect to recent federal death penalty legislation. A. The Aircraft Piracy Statute, 49 U.S.C. subsection 1472I, was enacted September 5th, 1961. The Senate vote on August 10th was 92-0. It was announced that Senators Chavez, Fulbright, Neuberger, and Symington were absent, but that, if present, all four would vote yea. That it was also announced on the other side of the aisle that Senator Butler was ill and that Senators Beale, Carlson, and Morton were absent or detained, but that those four, if present, would vote in the affirmative. These announcements therefore indicate that the true vote was 100-0. The House passed the bill without recorded vote. The presidential assassination statute was approved August 28, 1965, without recorded votes. The Omnibus Crime Control Act of 1970 was approved January 2, 1971. Title IV thereof added the Congressional Assassination Statute that is now 18 U.S.C. subsection 351. The recorded House vote on October 7, 1970 was 341 to 26, with 63 not voting and 62 of those paired. The Senate vote on October 8th was 59-0, with 41 not voting, but with 21 of these announced as favoring the bill. Final votes after conference were not recorded. It is impossible for me to believe that the many lawyer members of the House and Senate, including, I might add, outstanding leaders and prominent candidates for higher office, were callously unaware and insensitive of the constitutional overtones in legislation of this type. The answer, of course, is that in 1961, in 1965, and in 1970, these elected representatives of the people, far more conscious of the temper of the times, of the maturing of society, and of the contemporary demands for man's dignity, than are we who sit cloistered on this court. Took it as settled that the death penalty then, as it always has been, was not in itself unconstitutional. Some of those members of Congress, I suspect, will be surprised at this court's giant stride today. 9. If the reservations expressed by my brother Stuart, which, as I read his opinion, my brother White shares, were to command support, namely that capital punishment may not be unconstitutional so long as it be mandatorily imposed, the result, I fear, will be that statutes struck down today will be reenacted by state legislatures to prescribe the death penalty for specified crimes without any alternative for the imposition of a lesser punishment in the discretion of the judge or jury, as the case may be. This approach, it seems to me, encourages legislation that is regressive and of an antique mold. For it eliminates the element of mercy in the imposition of punishment. I thought we had passed beyond that point in our criminology long ago. 10. It is not without interest, also, to note that, although the several concurring opinions acknowledge the heinous and atrocious character of the offenses committed by the petitioners, none of those opinions makes reference to the misery of the petitioners' crimes occasioned to the victims, to the families of the victims, and to the communities where the offenses took place. The arguments for the respective petitioners, particularly the oral arguments, were similarly and curiously devoid of reference to the victims. There is risk, of course, in a comment such as this, for it opens one to the charge of emphasizing the retributive. But see Williams v. New York. Nevertheless, these cases are here because offenses to innocent victims were perpetrated. This fact, and the terror that occasioned it, and the fear that stalks the streets of many of our cities today, perhaps deserves not to be entirely overlooked. Let us hope that, with the court's decision, the terror imposed will be forgotten by those upon whom it was visited, and that our society will reap the hoped-for benefits of magnanimity. Although I may rejoice at the court's result, I find it difficult to accept or to justify as a matter of history or of law or of constitutional pronouncement. I fear the court has overstepped. It has sought and has achieved an end. The court granted certiorari in these cases to consider whether the death penalty is any longer a permissible form of punishment. It is the judgment of 5 justices that the death penalty, as customarily prescribed and implemented in this country today, offends the constitutional prohibition against cruel and unusual punishments. The reasons for that judgment are stated in 5 separate opinions, expressing as many separate rationales. In my view, none of these opinions provides a constitutionally adequate foundation for the court's decision. Mr. Justice Douglas concludes that capital punishment is incompatible with notions of equal protection, and he finds to be implicit in the Eighth Amendment. Mr. Justice Brennan bases his judgment primarily on the thesis that the penalty does not comport with human dignity. Mr. Justice Stewart concludes that the penalty is applied in a wanton and freakish manner. For Mr. Justice White, it is the infrequency with which the penalty is imposed that renders its use unconstitutional. Mr. Justice Marshall finds that capital punishment is an impermissible form of punishment because it is morally unacceptable and excessive. Although the central themes of petitioners' presentations in these cases is that the imposition of the death penalty is per se unconstitutional, only two of today's opinions explicitly conclude that so sweeping a determination is mandated by the Constitution. Both Mr. Justice Brennan and Mr. Justice Marshall call for the abolition of all existing state and federal capital punishment statutes. They intimate as well that no capital statute could be devised in the future that might comport with the Eighth Amendment. While the practical consequences of the other three opinions are less certain, they at least do not purport to render impermissible every possible statutory scheme for the use of capital punishment that legislatures might hereafter devise. Insofar as these latter options fail, at least explicitly, to go as far as petitioners' contentions would carry them, their reservations are attributable to a willingness to accept only a portion of petitioners' thesis. For the reasons cogently set out in the Chief Justice's dissenting opinion, and for reasons stated elsewhere in this opinion, I find my brother's less than absolute abolition judgment unpersuasive. Because those judgments are, for me, not dispositive, I shall focus primarily on the broader ground upon which the petitions in these cases are premised. The foundations of my disagreement with that broader thesis are equally applicable to each of the concurring opinions. I will therefore not endeavor to treat each one separately, nor will I attempt to predict what forms of capital statutes, if any, may avoid condemnation in the future, under the variety of views expressed by the collective majority today. That difficult task, not performed in any of the controlling opinions, must go unanswered until other cases presenting these more limited inquiries arise. Whatever uncertainties may hereafter surface, several of the consequences of today's decision are unmistakably clear. The decision is plainly one of the greatest importance. The court's judgment removes the death sentence previously imposed in some 600 persons awaiting punishment in state and federal prisons throughout the country. At least for the present, it also bars the states and the federal government from seeking sentences of death for defendants awaiting trial on charges for which capital punishment was heretofore a potential alternative. The happy event for these countable few constitutes, however, only the most visible consequence of this decision. Less measurable, but certainly no less significant, is the shattering effect this collection of views has on the root principles of stare decisis, federalism, judicial restraint, and, most importantly, separation of powers. The court rejects as not decisive the clearest evidence that the framers of the Constitution and the authors of the 14th Amendment believe that those documents posed no barrier to the death penalty. The court also brushes aside an unbroken line of precedent, reaffirming the heretofore virtually unquestioned constitutionality of capital punishment. Because of the pervasiveness of the constitutional ruling sought by petitioners and accepted in varying degree by 5 members of the court, today's departure from established precedent invalidates a staggering number of state and federal laws. The capital punishment laws of no less than 39 states and the District of Columbia are nullified. In addition, numerous provisions of the Criminal Code of the United States and of the Uniform Code of Military Justice are also voided. The court's judgment not only wipes out laws presently in existence, but denies to Congress and to the legislatures of the 50 states the power to adopt new policies contrary to the policies selected by the court. Indeed, it is the view of 2 of my brothers that the people of each state must be denied the prerogative to amend their constitutions to provide for capital punishment even selectively for the most heinous crime. In terms of the constitutional role of this court, the impact of the majority's ruling is all the greater because the decision encroaches upon an area squarely within the historic prerogative of the legislative branch, both state and federal, to protect the citizenry through the designation of penalties for prohibitable conduct. It is the very sort of judgment that the legislature branch is competent to make and for which the judiciary is ill-equipped. Throughout our history, justices of this court have emphasized the gravity of decisions invalidating legislative judgments, admonishing the 9 men who sit on this bench of the duty of self-restraint, especially when called upon to apply the expansive due process and cruel and unusual punishment rubrics. I can recall no case in which, in the name of deciding constitutional questions, this court has subordinated national and local democratic processes to such an extent. But before turning to address the thesis of petitioner's case against capital punishment, a thesis that has proved, at least in large measure, persuasive to a majority of this court, I first will set out the principles that counsel against the court's sweeping decision. The Constitution itself poses the first obstacle to petitioner's argument that capital punishment is per se unconstitutional. The relevant provisions are the 5th, 8th, and 14th Amendments. The first of these provides, in part, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor be deprived of life, liberty, or property without due process of law. Thus, the federal government's power was restricted in order to guarantee those charged with crimes that the prosecution would have only a single opportunity to seek imposition of the death penalty, and that the death penalty could not be exacted without due process and a grand jury indictment. The 14th Amendment, adopted about 77 years after the Bill of Rights, imposed the due process limitation of the 5th Amendment upon the state's power to authorize capital punishment. The 8th Amendment, adopted at the same time as the 5th, proscribes cruel and unusual punishments. In an effort to discern its meaning, much has been written about its history in the opinions of this court and elsewhere. That history need not be restated here, since whatever punishments the framers of the Constitution may have intended to prohibit under the cruel and unusual language, there cannot be the slightest doubt that they intended no absolute bar on the government's authority to impose the death penalty. As much is made clear by the 3 references to capital punishment in the 5th Amendment. Indeed, the same body that proposed the 8th Amendment also provided in the First Crimes Act of 1790 for the death penalty for a number of offenses. Of course, the specific prohibitions within the Bill of Rights are limitations on the exercise of power. They are not an affirmative grant of power to the government. I therefore do not read the several references to capital punishment as foreclosing this court from considering whether the death penalty in a particular case offends the 8th and 14th Amendments, nor are cruel and unusual punishments and due process of law static concepts whose meaning and scope were sealed at the time of their writing. They were designed to be dynamic and to gain meaning through application to specific circumstances, many of which were not contemplated by their authors. While flexibility in the application of these broad concepts is one of the hallmarks of our system of government, the court is not free to read into the Constitution a meaning that is plainly at variance with its language. Both the language of the 5th and 14th Amendments and the history of the 8th Amendment confirm beyond doubt that the death penalty was considered to be a constitutionally permissible punishment. It is, however, within the historic process of constitutional adjudication to challenge the imposition of the death penalty in some barbaric manner or as a penalty wholly disproportionate to a particular criminal act. And in making such a judgment in a case before it, a court may consider contemporary standards to the extent they are relevant. While this weighing of a punishment against the 8th Amendment standard on a case-by-case basis is consonant with history and precedent, it is not what petitioners demand in these cases. They seek nothing less than the total abolition of capital punishment by judicial fiat. Petitioners assert that the constitutional issue is an open one uncontrolled by prior decisions of this court. They view the several cases decided under the 8th Amendment as assuming the constitutionality of the death penalty without focusing squarely upon the issue. I do not believe that the case law can be so easily cast aside. The court, on numerous occasions, has both assumed and asserted the constitutionality of capital punishment. In several cases, that assumption provided a necessary foundation for the decision as the issue was whether a particular means of carrying out a capital sentence would be allowed to stand. Each of those decisions necessarily was premised on the assumption that some method of exacting the penalty was permissible. The issue in the first capital case in which the 8th Amendment was invoked, Wilkerson v. Utah, was whether carrying out a death sentence by public shooting was cruel and unusual punishment. A unanimous court upheld that form of execution, noting first that the punishment itself, as distinguished from the mode of its infliction, was not pretended by the counsel of the prisoner to be cruel and unusual. The court went on to hold that cruel and unusual punishments are forbidden by the Constitution, but the authorities are quite sufficient to show that the punishment of shooting as a mode of executing the death penalty for the crime of murder in the first degree is not included in that category. "11 years later, in Re Kemmler, the court again faced a question involving the method of carrying out a capital sentence. On review of a denial of habeas corpus relief by the Supreme Court of New York, this court was called on to decide whether electrocution, which only very recently had been adopted by the New York legislature as a means of execution, was impermissibly cruel and unusual in violation of the 14th Amendment. Chief Justice Fuller, speaking for the entire court, ruled in favor of the state. Electrocution has been selected by the legislature after careful investigation as the most humane and practical method known to modern science of carrying into effect the sentence of death. The court drew a clear line between the penalty itself and the mode of its execution. Punishments are cruel when they involve torture or a lingering death, but the punishment of death is not cruel within the meaning of that word as used in the Constitution. It implies there's something inhuman and barbarous, something more than the mere extinguishment of life. More than 50 years later, in Louisiana ex rel. Francis v. Resweber, the court considered a case in which, due to a mechanical malfunction, Louisiana's initial attempt to electrocute a convicted murderer had failed. Petitioner sought to block a second attempt to execute the sentence on the ground that to do so would constitute cruel and unusual punishment. In the plurality opinion written by Mr. Justice Reed, concurred in by Chief Justice Vinson and Justice Black and Jackson, relief was denied. Again, the court focused on the manner of execution, never questioning the propriety of the death sentence itself. The case before us does not call for an examination into any punishments except that for death. The traditional humanity of modern Anglo-American law forbids the infliction of unnecessary pain in the execution of the death sentence. The cruelty against which the Constitution protects a convicted man is cruelty inherent in the method of punishment, not the necessary suffering involved in any method employed to extinguish life humanely. Mr. Justice Frankfurter, unwilling to dispose of the case under the Eighth Amendment's specific prohibition, approved the second execution attempt under the Due Process Clause. He concluded that a state may be found to deny a person due process by treating even one guilty of crime in a manner that violates standards of decency more or less universally accepted, though not when it treats him by a mode about which opinion is fairly divided. The four dissenting justices, although finding a second attempt at execution to be impermissibly cruel, expressly recognized the validity of capital punishment. In determining whether the proposed procedure is unconstitutional, we must measure it against a lawful electrocution. Electrocution, when instantaneous, can be inflicted by a state in conformity with due process of law. The all-important consideration is that the execution shall be so instantaneous and substantially painless that the punishment shall be reduced as nearly as possible, to no more than that of death itself. Each of these cases involved the affirmance of a death sentence where its validity was attacked as violating the Eighth Amendment. 5 opinions were written in these 3 cases, expressing the views of 23 justices. While in the narrowest sense it is correct to say that in none was there a frontal attack upon the constitutionality of the death penalty, each opinion went well beyond an unarticulated assumption of validity. The power of the states to impose capital punishment was repeatedly and expressly recognized. In addition to these cases in which the constitutionality of the death penalty was a necessary foundation for the decision, those who today would have this court undertake the absolute abolition of the death penalty also must reject the opinions of other cases stipulating or assuming the constitutionality of capital punishment. The plurality opinion in Trop v. Dulles is of special interest since it is this opinion, in large measure, that provides the foundation for the present attack on the death penalty. It is anomalous that the standard urged by petitioners, evolving standards of decency that mark the progress of a maturing society, should be derived from an opinion that so unqualifiedly rejects their arguments. Chief Justice Warren, joined by Justices Black, Douglas, and Whitaker, stated flatly, "At the outset, let us put to one side the death penalty as an index of the constitutional limit on punishment. Whatever the arguments may be against capital punishment, both on moral grounds and in terms of accomplishing the purposes of punishment, and they are forceful, the death penalty has been employed throughout our history, and in a day when it is still widely accepted, it cannot be said to violate the constitutional concept of cruelty. The issue in Trop was whether forfeiture of citizenship was a cruel and unusual punishment when imposed on a wartime deserter who had gone over the hill for less than a day and had willingly surrendered. In examining the consequences of the relatively novel punishment of denationalization, Chief Justice Warren drew a line between traditional and unusual penalties. While the state has the power to punish, the Eighth Amendment stands to assure that this power be exercised within the limits of civilized standards. Fines, imprisonments, and even execution may be imposed, depending upon the enormity of the crime, but any technique outside the bounds of these traditional penalties is constitutionally suspect. The plurality's repeated disclaimers of any attack on capital punishment itself must be viewed as more than offhand dicta, since those views were written in direct response to the strong language in Mr. Justice Frankfurter's dissent, arguing that denationalization could not be a disproportionate penalty for a concededly capital offense. The most recent precedents of this court, Witherspoon v. Illinois and Magatha v. California, are also premised to a significant degree on the constitutionality of the death penalty. While the scope of review in both cases was limited to questions involving the procedures for selecting juries and regulating their deliberations in capital cases, those opinions were singularly academic exercises, if the members of this court were prepared at those times to find in the Constitution the complete prohibition of the death penalty. This is especially true of Mr. Justice Harlan's opinion for the court in Magatha, in which, after a full review of the history of capital punishment, he concluded that we find it quite impossible to say that committing to the untrammeled discretion of the jury the power to pronounce life or death in capital cases is offensive to anything in the Constitution. Perhaps enough has been said to demonstrate the unswerving position that this court has taken in opinions spanning the last 100 years. On virtually every occasion that any opinion has touched on the question of the constitutionality of the death penalty, it has been asserted affirmatively or tacitly assumed that the Constitution does not prohibit the death penalty. No justice of the court until today has dissented from this consistent reading of the Constitution. The petitioners in these cases now before the court cannot fairly avoid the weight of this substantial body of precedent merely by asserting that there is no prior decision precisely in point. Stare decisis, if it is a doctrine founded on principle, surely applies where there exists a long line of cases endorsing or necessarily assuming the validity of a particular matter of constitutional interpretation. Now, while these oft-repeated expressions of unchallenged belief in the constitutionality of capital punishment may not justify a summary disposition of the constitutional question before us, they are views expressed and joined in over the years by no less than 29 justices of this court, and therefore merit the greatest respect. Those who now resolve to set those views aside indeed have a heavy burden. Petitioners seek to avoid the authority of the foregoing cases and the weight of express recognition in the Constitution itself by reasoning which will not withstand analysis. The thesis of petitioner's case derives from several opinions in which members of this court have recognized the dynamic nature of the prohibition against cruel and unusual punishments. The final meaning of those words was not set in 1791. Rather, to use the words of Chief Justice Earl Warren, speaking for a plurality of the court in Trop v. Dulles, the words of the amendment are not precise, and their scope is not static. The amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. But this was not new doctrine. It was the approach to the Eighth Amendment taken by Mr. Justice McKenna in his opinion for the court in Weems v. United States. Writing for 4 justices, sitting as the majority of the 6-man court deciding the case, he concluded that the clause must be progressive. It is not fastened to the obsolete, but may acquire meaning as public opinion becomes enlightened by a humane justice. The same test was offered by Mr. Justice Frankfurter in his separate concurrence in Louisiana ex rel. Francis v. Resweber. While he rejected the notion that the 14th Amendment made the 8th Amendment fully applicable to the states, he nonetheless found as a matter of due process that the states were prohibited from treating even one guilty of crime in a manner that violates standards of decency more or less universally accepted. Whether one views the question as one of due process or of cruel and unusual punishment, as I do for convenience in this case, the issue is essentially the same. The fundamental premise upon which either standard is based is that notions of what constitutes cruel and unusual punishment or due process do evolve. Neither the Congress nor any state legislature would today tolerate pillorying, branding, or cropping, or nailing of the ears, punishments that were in existence during our colonial era. Should, however, any such punishment be prescribed, the courts would certainly enjoin its execution. Likewise, no court would approve any method of implementation of the death sentence found to involve unnecessary cruelty in light of presently available alternatives. Similarly, there may well be a process of evolving attitude with respect to the application of the death sentence for particular crimes. But we are not asked to consider the permissibility of any of the several methods employed in carrying out the death sentence. Nor are we asked, at least as part of the course submission in these cases, to determine whether the penalty might be a grossly excessive punishment for some specific criminal conduct. Either inquiry would call for a discriminating evaluation of particular means, or of the relationship between particular conduct and its punishment. Petitioner's principal argument goes far beyond the traditional process of case-by-case inclusion and exclusion. Instead, the argument insists on an unprecedented constitutional rule of absolute prohibition of capital punishment for any crime, regardless of its depravity and impact on society. In calling for a precipitate and final judicial end to this form of penalty as offensive to evolving standards of decency, petitioners would have this court abandon the traditional and more refined approach consistently followed in its prior Eighth Amendment precedents. What they are saying, in effect, is that the evolutionary process has come suddenly to an end, that the ultimate wisdom as to the appropriateness of capital punishment under all circumstances and for all future generations has somehow been revealed. The prior opinions of this court point with great clarity to reasons why those of us who sit on this court at a particular time should act with restraint before assuming, contrary to a century of precedent, that we now know the answer for all time to come. First, whereas here, the language of the applicable provision provides great leeway, and where the underlying social policies are felt to be of vital importance. The temptation to read personal preference into the Constitution is understandably great. It is too easy to propound our subjective standards of wise policy under the rubric of more or less universally held standards of decency. The second consideration dictating judicial self-restraint arises from a proper recognition of the respective roles of the legislative and judicial branches. The designation of punishments for crimes is a matter peculiarly within the sphere of the state and federal legislative bodies. When asked to encroach on the legislative prerogative, we are well counseled to proceed with the utmost reticence. The review of legislative choices in the performance of our duty to enforce the Constitution has been characterized most appropriately by Mr. Justice Holmes as the gravest and most delicate duty that this court is called on to perform. How much graver is that duty when we are not asked to pass on the constitutionality of a single penalty under the facts of a single case, but instead are urged to overturn the legislative judgments of 40 state legislatures as well as those of Congress. In doing so, is the majority able to claim, as did the court in Weems, that it appreciates to the fullest the wide range of power that the legislature possesses to adapt its penal laws to conditions as they may exist and punish the crimes of men according to their forms and frequency. I think not. No more eloquent statement of the essential separation of powers limitation on our prerogative can be found in the admonition of Mr. Justice Frankfurter dissenting in Trop. His articulation of the traditional view takes on added significance where the court undertakes to nullify the legislative judgments of the Congress and 4/5 of the states. What is always basic when the power of Congress to enact legislation is challenged is the appropriate approach to judicial review of congressional legislation. When the power of Congress to pass a statute is challenged, the function of this court is to determine whether legislative action lies clearly outside the constitutional grant of power to which it has been or may fairly be referred. In making this determination, the court sits in judgment on the action of a coordinate branch of the government while keeping unto itself, as it must under our constitutional system, the final determination of its own power to act. Rigorous observance of the difference between limits of power and wise exercise of power, between questions of authority and questions of prudence, requires the most alert appreciation of this decisive but subtle relationship of two concepts that too easily coalesce. No less does it require a disciplined will to adhere to the difference. It is not easy to stand aloof and allow want of wisdom to prevail, to disregard one's own strongly held view of what is wise in the conduct of affairs. But it is not the business of this court to pronounce policy. It must observe a fastidious regard for limitations on its own power, and this precludes the court's giving effect to its own notions of what is wise and politic. That self-restraint is of the essence in the observance of the judicial oath, for the Constitution has not authorized the judges to sit in judgment on the wisdom of what Congress and the executive branch do. Although determining the range of available punishments for a particular crime is a legislative function, the very presence of the Cruel and Unusual Punishments Clause within the Bill of Rights requires, in the context of a specific case, that courts decide whether particular acts of the Congress offend that amendment. The Due Process Clause of the 14th Amendment imposes on the judiciary a similar objection to scrutinize state legislation. But the proper exercise of that constitutional obligation, in the cases before us today, must be founded on a full recognition of the several considerations set forth above, the affirmative references to capital punishment in the Constitution, the prevailing precedents of this court, the limitations on the exercise of our power imposed by tested principles of judicial self-restraint, and the duty to avoid encroachment on the powers conferred upon state and federal legislatures. In the face of these considerations, only the most conclusive of objective demonstrations could warrant this court in holding capital punishment per se unconstitutional. The burden of seeking so sweeping a decision against such formidable obstacles is almost insuperable. Viewed from this perspective, as I believe it must be, the case against the death penalty falls far short. Petitioners' contentions are premised, as indicated above, on the long-accepted view that concepts embodied in the 8th and 14th Amendments evolve. They present, with skill and persistence, a list of objective indicators which are said to demonstrate that prevailing standards of human decency have progressed to the final point of requiring the court to hold, for all cases and for all time, that capital punishment is unconstitutional. Briefly summarized, these proffered indicia of contemporary standards of decency include the following: a worldwide trend toward the disuse of the death penalty, the reflection in the scholarly literature of a progressive rejection of capital punishment founded essentially on moral opposition to such treatment, the decreasing numbers of executions over the last 40 years, and especially over the last decade, the small number of death sentences rendered in relation to the number of cases in which they might have been imposed, and the indication of public abhorrence of the penalty reflected in the circumstances that executions are no longer public affairs. The foregoing is an incomplete summary, but it touches the major bases of petitioners' presentation. Although they are not appropriate for consideration as objective evidence, petitioners strongly urge two additional propositions. They contend, first, that the penalty survives public condemnation only through the infrequency, arbitrariness, and discriminatory nature of its application, and second, that there no longer exists any legitimate justification for the utilization of the ultimate penalty. These contentions, which have proved persuasive to several of the justices constituting the majority, deserve separate considerations and will be considered in the ensuing sections. Before turning to those arguments, I first address the argument based on objective factors. Any attempt to discern contemporary standards of decency through the review of objective factors must take into account several overriding considerations which petitioners choose to discount or ignore. In a democracy, the first indicator of the public's attitude must always be found in the legislative judgments of the people's chosen representatives. Mr. Justice Marshall's opinion today catalogs the salient statistics. 40 states, the District of Columbia, and the federal government still authorize the death penalty for a wide variety of crimes. That number has remained relatively static since the end of World War I. That does not mean, however, that capital punishment has become a forgotten issue in the legislative arena. As recently as January 1971, Congress approved the death penalty for congressional assassination. In 1965, Congress added the death penalty for presidential and vice presidential assassinations. Additionally, the aircraft piracy statute, passed in 1961, also carries the death penalty. Mr. Justice Blackmun's dissenting opinion catalogs the impressive ease with which each of these statutes was approved. On the converse side, a bill proposing the abolition of capital punishment for all federal crimes was introduced in 1967, but failed to reach the Senate floor. At the state level, New York, among other states, has recently undertaken reconsideration of its capital crimes. A law passed in 1965 restricted the use of capital punishment to the crimes of murder of a police officer and murder by a person serving a sentence of life imprisonment. I pause here to state that I am at a loss to understand how those urging this court to pursue a course of absolute abolition as a matter of constitutional judgment can draw any support from the New York experience. As is also the case with respect to recent legislative activity in Canada and Great Britain, New York's decision to restrict the availability of the death penalty is a product of refined and discriminating legislative judgment, reflecting not the total rejection of capital punishment as inherently cruel, but a desire to limit it to those circumstances in which legislative judgment deems retention to be in the public interest. No such legislative flexibility is permitted. By the contrary course, petitioners urge this court to follow. In addition to the New York experience, a number of other states have undertaken reconsideration of capital punishment in recent years. In 4 states, the penalty has been put to a vote of the people through public referenda, a means likely to supply objective evidence of community standards. In Oregon, a referendum seeking abolition of capital punishment failed in 1958, but was subsequently approved in 1964. 2 years later, the penalty was approved but in Colorado by a wide margin. In Massachusetts in 1968, in an advisory referendum, the voters recommended retention of the penalty. In 1970, approximately 64% of the voters in Illinois approved the penalty. In addition, the National Commission on Reform of Federal Criminal Laws reports that legislative committees in Massachusetts, Pennsylvania, and Maryland recommended abolition, while committees in New Jersey and Florida recommended retention. The legislative views of other states have been summarized by Professor Hugo Bedau in his compilation of sources on capital punishment entitled The Death Penalty in America. What our legislative representatives think in the 2 states which still have the death penalty may be inferred from the fate of the bills to repeal or modify the death penalty filed during recent years in the legislatures of more than half of these states. In about a dozen instances, the bills emerged from committee for a vote. But in none except Delaware did they become law. In those states where these bills were brought to the floor of the legislatures, the vote in most instances wasn't even close. This recent history of activity with respect to legislation concerning the death penalty abundantly refutes the abolition position. The second and even more direct source of information reflecting the public's attitude toward capital punishment is the jury. Mr. Justice Stewart, joined by Justices Brennan and Marshall, characterized the jury's historic function in the sentencing process in the following terms. The jury is given broad discretion to decide whether or not death is the proper penalty in a given case, and a juror's general views about capital punishment play an inevitable role in any such decision. A man who opposes the death penalty, no less than one who favors it, can make the discretionary judgment entrusted to him by the state, and can thus obey the oath he takes as a juror. Guided by neither rule nor standard, a jury must choose between life imprisonment and capital punishment, can do little more, and must do nothing less than express the conscience of the community on the ultimate question of life or death. One of the most important functions any jury can perform in making such a selection is to maintain a link between contemporary community values and the penal system, a link without which the determination of punishment could hardly reflect the evolving standards of decency that mark the progress of a maturing society. Any attempt to discern, therefore, where the prevailing standards of decency lie must take careful account of the jury's response to the question of capital punishment. During the 1960s, juries returned in excess of 1,000 death sentences, a rate of approximately 2 per week. Whether it is true that death sentences were returned in less than 10% of the cases as petitioners estimate, or whether some higher percentage is more accurate, these totals simply do not support petitioners' assertion at oral argument that the death penalty is virtually unanimously repudiated and condemned by the conscience of contemporary society. It is also worthy of note that the annual rate of death sentences has remained relatively constant over the last 10 years, and that the figure for 1970 127 sentences is the highest annual total since 1961. It is true that the sentencing rate might be expected to rise, rather than remain constant, when the number of violent crimes increases as it has in this country, and it may be conceded that the constancy of these statistics indicates the unwillingness of juries to demand the ultimate penalty in many cases where it might be imposed. But these considerations fall short of indicating that juries are imposing the death penalty with such rarity as to justify this court in reading into this circumstance a public rejection of capital punishment. One must conclude, contrary to petitioner's submission, that the indicators most likely to reflect the public's view, legislative bodies, state referenda, and the juries, which have the actual responsibility, do not support the contention that evolving standards of decency require total abolition of capital punishment. Indeed, the weight of the evidence indicates that the public generally has not accepted either the morality or the social merit of the views so passionately advocated by the articulate spokesman for abolition. But, however, one may assess the amorphous ebb and flow of public opinion generally on this volatile issue. This type of inquiry lies at the periphery, not the core, of the judicial process in constitutional cases. The assessment of popular opinion is essentially a legislative, not a judicial function. Petitioners seek to salvage their thesis by arguing that the infrequency and discriminatory nature of the actual resort to the ultimate penalty tend to diffuse public opposition. We are told that the penalty is imposed exclusively on uninfluential minorities, the poor and powerless, personally ugly, and socially unacceptable. It is urged that this pattern of application assures that large segments of the public will be either uninformed or unconcerned and will have no reason to measure the punishment against prevailing moral standards. Implicitly, this argument concedes the unsoundness of petitioner's contention, examined above in Part 4, that objective evidence shows a present and widespread community rejection of the death penalty. It is now said, in effect, not that capital punishment presently offends our citizenry, but that the public would be offended if the penalty were enforced in a non-discriminatory manner against a significant percentage of those charged with capital crimes, and if the public were thereby made aware of the moral issues surrounding capital punishment. Rather than merely registering the objective indicators on a judicial balance, we are asked ultimately to rest a far-reaching constitutional determination on a prediction regarding the subjective judgments of the mass of our people under hypothetical assumptions that may or may not be realistic. Apart from the impermissibility of basing a constitutional judgment of this magnitude on such speculative assumptions, the argument suffers from other defects. If, as petitioners urge, we are to engage in speculation, it is not at all certain that the public would experience deep-felt revulsion if the states were to execute as many sentenced capital offenders this year as they executed in the mid-1930s. It seems more likely that public reaction, rather than being characterized by undifferentiated rejection, would depend upon the facts and circumstances surrounding each particular case. Members of this court know, from the petitioners and appeals that come before us regularly, that brutish and revolting murders continue to occur with disquieting frequency. Indeed, murders are so commonplace in our society that only the most sensational receive significant and sustained publicity. It could hardly be suggested that in any of these highly publicized murder cases, the several senseless assassinations, or the too numerous shocking multiple murders that have stained this country's recent history, the public has exhibited any signs of revulsion at the thought of executing the convicted murderers. The public outcry, as we all know, has been quite to the contrary. Furthermore, there is little reason to suspect that the public's reaction would differ significantly in response to other less publicized murders. It is certainly arguable that many such murders, because of their senselessness or barbarousness, would evoke a public demand for the death penalty rather than a public rejection of that alternative. Nor is there any rational basis for arguing that the public reaction to any of these crimes would be muted if the murderer were rich and powerful. The demand for the ultimate sanction might well be greater, as a wealthy killer is hardly a sympathetic figure. While there might be specific cases in which capital punishment would be regarded as excessive and shocking to the conscience of the community, it can hardly be argued that the public's dissatisfaction with the penalty in particular cases would translate into a demand for absolute abolition. In pursuing the foregoing speculation, I do not suggest that it is relevant to the appropriate disposition of these cases. The purpose of the digression is to indicate that judicial decisions cannot be founded on such speculations and assumptions, however appealing they may seem. But the discrimination argument against does not rest alone on a projection of the assumed effect on public opinion of more frequent executions. Much also is made of the undeniable fact that the death penalty has a greater impact on the lower economic strata of society, which include a relatively higher percentage of persons of minority racial and ethnic group backgrounds. The argument drawn from this fact is two-pronged. In part, it is merely an extension of the speculative approach pursued by petitioners that public revulsion is suppressed in callous apathy because the penalty does not affect persons from the white middle class, which constitutes the majority in this country. This aspect, however, adds little to the infrequency rationalization for public apathy which I have found unpersuasive. As Mr. Justice Marshall's opinion today demonstrates, the argument does have a more troubling aspect. It is his contention that if the average citizen were aware of the disproportionate burden of capital punishment borne by the poor, the ignorant, and the underprivileged, he would find the penalty shocking to his conscience and sense of justice, and would not stand for its further use. This argument, like the apathy rationale, calls for further speculation on the part of the court. It also illuminates the quicksands upon which we are asked to base this decision. Indeed, the two contentions seem to require contradictory assumptions regarding the public's moral attitude toward capital punishment. The apathy argument is predicated on the assumption that the penalty is used against the less influential elements of society, that the public is fully aware of this, and that it tolerates use of capital punishment only because of a callous indifference to the offenders who are sentenced. Mr. Justice Marshall's argument, on the other hand, rests on the contrary assumption that the public does not know against whom the penalty is enforced, and that if the public were educated to this fact, it would find the punishment intolerable. Neither assumption can claim to be an entirely accurate portrayal of public attitude, for some acceptance of capital punishment might be a consequence of hardened apathy based on the knowledge of infrequent and uneven application, while for others acceptance may grow only out of ignorance. More significantly, however, neither supposition acknowledges what, for me, is a more basic flaw. Certainly, the claim is justified that this criminal sanction falls more heavily on the relatively impoverished and underprivileged elements of society. The have-nots in every society always have been subject to greater pressure to commit crimes and to fewer constraints than their more affluent fellow citizens. This is, indeed, a tragic byproduct of social and economic deprivation, but it is not an argument of constitutional proportions under the 8th or 14th Amendment. The same discriminatory impact argument could be made with equal force and logic with respect to those sentenced to prison terms. The Due Process Clause admits of no distinction between the deprivation of life and the deprivation of liberty. If discriminatory impact renders capital punishment cruel and unusual, it likewise renders invalid most of the prescribed penalties for crimes of violence. The root causes of the higher incidence of criminal penalties on minorities and the poor will not be cured by abolishing the system of penalties. Nor indeed could any society have a viable system of criminal justice if sanctions were abolished or ameliorated, because most of those who commit crimes happen to be underprivileged. The basic problem results not from the penalties imposed for criminal conduct, but from social and economic factors that have plagued humanity since the beginning of recorded history, frustrating all efforts to create in any country at any time the perfect society in which there are no poor, no minorities, and no underprivileged. The causes underlying this problem are unrelated to the constitutional issue before the court. Finally, yet another theory for abolishing the death penalty, reflected in varying degrees in each of the concurring opinions today, is predicated on the discriminatory impact argument. Quite apart from measuring the public's acceptance or rejection of the death penalty under the standards of decency rationale, Mr. Justice Douglas finds the punishment cruel and unusual because it is arbitrarily invoked. He finds that the basic theme of equal protection is implicit in the Eighth Amendment, and that the amendment is violated when jury sentencing may be characterized as arbitrary or discriminatory. While Mr. Justice Stewart does not purport to rely on notions of equal protection, he also rests primarily on what he views to be a history of arbitrariness. Whatever may be the facts with respect to jury sentencing, this argument calls for a reconsideration of the standards aspect of the court's decision in McGautha v. California. Although that is the unmistakable thrust of these opinions today, I see no reason to reassess the standards question considered so carefully in Mr. Justice Harlan's opinion for the court last term. Having so recently reaffirmed our historic dedication to entrusting the sentencing function to the jury's untrammeled discretion, it is difficult to see how the court can now hold the entire process constitutionally defective under the Eighth Amendment. For all of these reasons, I find little merit in the various discrimination arguments, at least in the several lights in which they have been cast in these cases. Although not presented by any of the petitioners today, a different argument premised on the Equal Protection Clause might well be made. If an African American defendant, for instance, could demonstrate that members of his race were being singled out for more severe punishment than others charged with the same offense, a constitutional violation might be established. This was the contention made in Maxwell v. Bishop, vacated and remanded on other grounds, in which the Eighth Circuit was asked to issue a writ of habeas corpus, setting aside a death sentence imposed on an African American defendant convicted of rape. In that case, substantial statistical evidence was introduced tending to show a pronounced disproportion in the number of African Americans receiving death sentences for rape in parts of Arkansas and elsewhere in the South. That evidence was not excluded, but was found to be insufficient to show discrimination in sentencing in Maxwell's trial. Mr. Justice Blackmun, then sitting on the Court of Appeals for the Eighth Circuit, concluded, "The petitioner's argument is an interesting one, and we are not disposed to say that it could not have some validity and weight in certain situations. Like the trial court, however, we feel that the argument does not have validity and pertinent application to Maxwell's case. We are not yet ready to condemn and upset the result reached in every case of an African American rape defendant in the state of Arkansas on the basis of broad theories of social and statistical injustice. We do not say that there is no ground for suspicion that the death penalty for rape may have been discriminatorily applied over the decades in that large area of states whose statutes provide for it. There are recognizable indicators of this, but improper state practice of the past does not automatically invalidate a procedure of the present. I agree that discriminatory application of the death penalty in the past, admittedly indefensible, is no justification for holding today that capital punishment is invalid in all cases in which sentences were handed out to members of the class discriminated against. But Maxwell does point the way to a means of raising the equal protection challenge that is more consonant with precedent and the Constitution's mandates than the several courses pursued by today's concurring opinions. A final comment on the racial discrimination problem seems appropriate. The possibility of racial bias in the trial and sentencing process has diminished in recent years. The segregation of our society in decades past, which contributed substantially to the severity of punishment for interracial crimes, is now no longer prevalent in this country. Likewise, the day is past when juries do not represent the minority group elements of the community. The assurance of fair trials for all citizens is greater today than at any previous time in our history. Because standards of criminal justice have evolved in a manner favorable to the accused, discriminatory imposition of capital punishment is far less likely today than in the past. Petitioner in Branch v. Texas, and to a lesser extent the petitioners in other cases before us today, urge that capital punishment is cruel and unusual because it no longer serves any rational legislative interests. Before turning to consider whether any of the traditional aims of punishment justify the death penalty, I should make clear the context in which I approach this aspect of the cases. First, I find no support in the language of the Constitution, in its history, or in the cases arising under it for the view that this court may invalidate a category of penalties because we deem less severe penalties adequate to serve the ends of penology. While the cases affirm our authority to prohibit punishments that are cruelly inhumane, the precedents of this court afford no basis for striking down a particular form of punishment because we may be persuaded that means less stringent would be equally efficacious. Secondly, if we were free to question the justifications for the use of capital punishment, a heavy burden would rest on those who attack the legislature's judgments to prove the lack of rational justifications. This court has long held that legislative decisions in this area, which lie within the special competency of that branch, are entitled to a presumption of validity. I come now to consider, subject to the reservations above expressed, the two justifications most often cited for the retention of capital punishment. The concept of retribution, though popular for centuries, is now criticized as unworthy of a civilized people. Yet this court has acknowledged the existence of a retributive element in criminal sanctions and has never heretofore found it impermissible. In Williams v. New York, Mr. Justice Black stated that retribution is no longer the dominant objective of the criminal law. Reformation and rehabilitation of offenders have become important goals of criminal jurisprudence. It is clear, however, that the court did not reject retribution altogether. The record in that case indicated that one of the reasons why the trial judge imposed the death penalty was his sense of revulsion at the shocking details of the crime. Although his motivation was clearly retributive, the court upheld the trial judge's sentence. Similarly, Mr. Justice Marshall noted in his plurality opinion in Powell v. Texas that the court has never held that anything in the Constitution requires that penal sanctions be designed solely to achieve therapeutic or rehabilitative effects. While retribution alone may seem an unworthy justification in a moral sense, its utility in a system of criminal justice requiring public support has long been recognized. Lord Justice Denning, now Master of the Rolls of the Court of Appeal in England, testified on this subject before the British Royal Commission on Capital Punishment. Many are inclined to test the efficacy of punishment solely by its value as a deterrent, but this is too narrow a view. Punishment is the way in which society expresses its denunciation of wrongdoing, and in order to maintain respect for law, it is essential that the punishment inflicted for grave crimes should adequately reflect the revulsion felt by the great majority of citizens for them. It is a mistake to consider the objects of punishment as being deterrent or reformative or preventative and nothing else. If this were so, we should not send to prison a man who was guilty of motor manslaughter, but only disqualify him from driving. But would public opinion be content with this? The truth is that some crimes are so outrageous that society insists on adequate punishment, because the wrongdoer deserves it, irrespective of whether it is a deterrent or not. The view expressed by Lord Denning was cited approvingly in the Royal Commission's report, recognizing a strong and widespread demand for retribution. Mr. Justice Stewart makes the same point in his opinion today when he concludes that expression of man's retributive instincts in the sentencing process serves an important purpose in promoting the stability of a society governed by law. The view, moreover, is not without respectable support in the jurisprudential literature in this country, despite a substantial body of opinion to the contrary, and it is conceded on all sides that, not infrequently, cases arise that are so shocking or offensive that the public demands the ultimate penalty for the transgressor. Deterrence is a more appealing justification, although opinions again differ widely. Indeed, the deterrence issue lies at the heart of much of the debate between the abolitionists and retentionists. Statistical studies based primarily on trends in states that have abolished the death penalty tend to support the view that the death penalty has not been proved to be a superior deterrent. Some dispute the validity of this conclusion, pointing out that the studies do not show that the death penalty has no deterrent effect on any categories of crimes. On the basis of the literature and studies currently available, I find myself in agreement with the conclusions drawn by the Royal Commission following its exhaustive study of this issue. The general conclusion which we reach after careful review of all the evidence we have been able to obtain as to the deterrent effect of capital punishment may be stated as follows. Prima facie, the penalty of death is likely to have a stronger effect as a deterrent to normal human beings than any other form of punishment, and there is some evidence, though no convincing statistical evidence, that this is in fact so. But this effect does not operate universally or uniformly, and there are many offenders on whom it is limited and may often be negligible. It is accordingly important to view this question in a just perspective and not base a penal policy in relation to murder on exaggerated estimates of the uniquely deterrent force of the death penalty. Only recently, this court was called on to consider the deterrence argument in relation to punishment by fines for public drunkenness. The court was unwilling to strike down the Texas statute on grounds that it lacked a rational foundation. What Mr. Justice Marshall said there would seem to have equal applicability in this case. The long-standing and still raging debate over the validity of the deterrence justification for penal sanctions has not reached any sufficiently clear conclusions to permit it to be said that such sanctions are ineffective in any particular context or for any particular group of people who are able to appreciate the consequences of their acts. As I noted at the outset of this section, legislative judgments as to the efficacy of particular punishments are presumptively rational and may not be struck down under the Eighth Amendment because this court may think that some alternative sanction would be more appropriate. Even if such judgments were within the judicial prerogative, petitioners have failed to show that there exist no justifications for the legislative enactments challenged in these cases. While the evidence and arguments advanced by petitioners might have proved profoundly persuasive if addressed to a legislative body, they do not approach the showing traditionally required before a court declares that the legislature has acted irrationally. In two of the cases before us today, juries imposed sentences of death after convictions of rape. In these cases, we are urged to hold that even if capital punishment is permissible for some crimes, it is a cruel and unusual punishment for this crime. Petitioners in these cases rely on the court's opinions, holding that the Eighth Amendment, in addition to prohibiting punishments deemed barbarous and inhumane, also condemns punishments that are greatly disproportionate to the crime charged. This reading of the amendment was first expressed by Mr. Justice Field in his dissenting opinion in O'Neill v. Vermont, a case in which a defendant charged with a large number of violations of Vermont's liquor laws received a fine in excess of $6,600 or a 54-year jail sentence if the fine was not paid. The majority refused to consider the question on the ground that the Eighth Amendment did not apply to the states. The dissent, after carefully examining the history of that amendment and the 14th, concluded that its prohibition was binding on Vermont and that it was directed against all punishments which, by their excessive length or severity, are greatly disproportioned to the offense charged. The court in Weems v. United States adopted Mr. Justice Field's view. The defendant in Weems, charged with falsifying government documents, had been sentenced to serve 15 years in cadena temporal, a punishment which included carrying chains at the wrists and ankles and the perpetual loss of the right to vote and hold office. Finding the sentence grossly excessive in length and condition of imprisonment, the court struck it down. This notion of disproportionality, that particular sentences may be cruelly excessive for particular crimes, has been cited with approval in more recent decisions of this court. See Robinson v. California, Trott v. Dulles, see also Howard v. Fleming. These cases, while providing a rationale for gauging the constitutionality of capital sentences imposed for rape, it also indicates also indicate the existence of necessary limitations on the judicial function. The use of limiting terms in the various expressions of this test found in the opinions, grossly excessive, greatly disproportionate, emphasizes that the court's power to strike down punishments as excessive must be exercised with the greatest circumspection. As I have noted earlier, nothing in the history of the cruel and unusual punishments clause indicates that it may properly be utilized by the judiciary to strike down punishments authorized by legislatures and imposed by juries in any but the extraordinary case. This court is not empowered to sit as a court of sentencing review, implementing the personal views of its members on the proper role of penology. To do so is to usurp a function committed to the legislative branch and beyond the power and competency of this court. Operating within these narrow limits, I find it quite impossible to declare the death sentence grossly excessive for all rapes. Rape is widely recognized as among the most serious of violent crimes, as witnessed by the very fact that it is punishable by death in 16 states and by life imprisonment in most other states. The several reasons why rape stands so high on the list of serious crimes are well known. It is widely viewed as the most atrocious of intrusions upon the privacy and dignity of the victim. Never is the crime committed accidentally. Rarely can it be said to be unpremeditated. Often the victim suffers serious physical injury. The psychological impact can often be as great as the physical consequences. In a real sense, the threat of both types of injury is always present. For these reasons, and for the reasons arguing against abolition of the death penalty altogether, the excessiveness rationale provides no basis for rejecting the penalty for rape in all cases. The argument that the death penalty for rape lacks rational justification because less severe punishments might be viewed as accomplishing the proper goals of penology is as inapposite here as it was in considering per se abolition. The state of knowledge with respect to the deterrent value of the sentence for this crime is inconclusive. Moreover, what has been said about the concept of retribution applies with equal force where the crime is rape. There are many cases in which the sordid, heinous nature of a particular crime, demeaning, humiliating, and often physically or psychologically traumatic, will call for public condemnation. In a period of our country's history when the frequency of this crime is increasing alarmingly. In a period of our country's history when the frequency of this crime is increasing alarmingly. It is indeed a grave event for the court to take from the states whatever deterrent and retributive weight the death penalty retains. Other less sweeping applications of the disproportionality concept have been suggested. Recently, the Fourth Circuit struck down a death sentence in Ralph v. Warden, holding that the death penalty was an appropriate punishment for rape only when life is endangered. Chief Justice Hainsworth, who joined in the panel's opinion, wrote separately in denying the state of Maryland's petition for rehearing in order to make clear the basis for his joinder. He stated that for him, the appropriate test was not whether life was endangered, but whether the victim in fact suffered grievous physical or psychological harm. It seems to me that both of these tests depart from established principles and also raise serious practical problems. How are those cases in which the victim's life is endangered to be distinguished from those in which no danger is found? The threat of serious injury is implicit in the definition of rape. The victim is either forced into submission by physical violence or by the threat of violence. Certainly that test would provide little comfort for either of the rape defendants in the case presently before us. Both criminal acts were accomplished only after a violent struggle. Petitioner Jackson held a scissor blade against his victim's neck. Petitioner Branch had less difficulty subduing his 65-year-old victim. Both assailants threatened to kill their victims. The alternative test, limiting the penalty to cases in which the victim suffers physical or emotional harm, might present even greater problems of application. While most physical effects may be seen and objectively measured, the emotional impact may be impossible to gauge at any particular point in time. The extent and duration of psychological trauma may not be known or ascertainable prior to the date of trial. While I reject each of these attempts to establish specific categories of cases in which the death penalty may be deemed excessive, I view them as groping toward what is for me the appropriate application of the Eighth Amendment. while in my view the disproportionality test may not be used either to strike down the death penalty for rape altogether or to install the court as a tribunal for sentencing review, that test may find its application in the peculiar circumstances of specific cases. Its utilization should be limited to the rare case in which the death penalty is rendered for a crime technically falling within the legislatively defined class, but factually falling outside the likely legislative intent in creating the category. Specific rape cases, and specific homicides as well, can be imagined in which the conduct of the accused would render the ultimate penalty a grossly excessive punishment. Although this case-by-case approach may seem painfully slow and inadequate to those who wish the court to assume an activist legislative role in reforming criminal punishments, it is the approach dictated both by our prior opinions and by a due recognition of the limitations of judicial power. This approach, rather than the majority's more persuasive and less refined judgment, marks for me the appropriate course under the Eighth Amendment. I now return to the overriding question in these cases, whether this court, acting in conformity with the Constitution, can justify its judgment to abolish capital punishment as heretofore known in this country. It is important to keep in focus the enormity of the step undertaken by the court today. Not only does it invalidate hundreds of state and federal laws, it deprives those jurisdictions of the power to legislate with respect to capital punishment in the future, except in a manner consistent with the cloudily outlined views of those justices who do not purport to undertake total abolition. Nothing short of an amendment to the United States Constitution can reverse the court's judgments. Meanwhile, all flexibility is foreclosed. The normal democratic process, as well as the opportunities for the several states to respond to the will of their people expressed through ballot referenda, as in Massachusetts, Illinois, and Colorado, is now shut off. The sobering disadvantage of constitutional adjudication of this magnitude is the universality and permanence of the judgment. The enduring merit of legislative action is its responsiveness to the democratic process, and to revision and change, mistaken judgments may be corrected and refinements perfected. In England and Canada, critical choices were made after studies canvassing all competing views, and in those countries, revisions may be made in light of experience. As recently as 1967, a presidential commission did consider, as part of an overall study of crime in this country, whether the death penalty should be abolished. The commissioner's unanimous recommendation was as follows. The question whether capital punishment is an appropriate sanction is a policy decision to be made by each state. Where it is retained, the types of offenses for which it is available should be strictly limited, and the law should not be enforced in an even-handed and non-discriminatory manner, with procedures for a review of death sentences that are fair and expeditious. When a state finds that it cannot administer the penalty in such a manner, or that the death penalty is being imposed but not carried into effect, the penalty should be abandoned. The thrust of the Commission's recommendation, as presently relevant, is that this question is a policy decision to be made by each state. There is no hint that this decision could or should be made by the judicial branch. The National Commission on Reform of Federal Criminal Laws also considered the capital punishment issue. The introductory commentary of its final report states that a sharp division existed within the Commission on the subject of capital punishment, although a majority favored its abolition. Again, consideration of the question was directed to the propriety of retention or abolition as a legislative matter. That there was no suggestion that the difference of opinion existing among commission members and generally across the country could or should be resolved in one stroke by a decision of this court. Similar activity was, before today, evident at the state level, with re-evaluation having been undertaken by special legislative committees in some states and by public ballot in others. With deference and respect for the views of the justices who differ, it seems to me that all these studies, both in this country and elsewhere, suggest that, as a matter of policy and precedent, this is a classic case of the exercise of our oft-announced allegiance to judicial restraint. I know of no case in which greater gravity and delicacy have attached to the duty that this court is called on to perform whenever legislation, state or federal, is challenged on constitutional grounds. It seems to me that the sweeping judicial action undertaken today reflects a basic lack of faith and confidence in the democratic process. Many may regret, as I do, the failures of some legislative bodies to address the capital punishment issue with greater frankness or effectiveness. Many might decry their failure either to abolish the death penalty entirely or selectively, or to establish standards for its enforcement. But impatience with the slowness and even the unresponsiveness of legislatures is no justification for judicial intrusion upon their historic powers. Rarely has there been a more appropriate opportunity for this court to heed the philosophy of Mr. Justice Oliver Wendell Holmes, as Mr. Justice Frank Ferner reminded the court in Trop. The whole of Mr. Justice Holmes' work during his 30 years of service on this court should be a constant reminder that the power to invalidate legislation must not be exercised as if, either in constitutional theory or in the art of government, it stood as the sole bulwark against unwisdom or excesses of the moment. Mr. Justice Rehnquist, with whom the Chief Justice, Mr. Justice Blackmun, and Mr. Justice Powell joined dissenting. The court's judgment today strikes down a penalty that our nation's legislatures have thought necessary since our country was founded. My brothers Douglas, Brennan, and Marshall would at one fell swoop invalidate laws enacted by Congress and 40 of the 50 state legislatures, and would consign to the limbo of unconstitutionality under a single rubric penalties for offenses as varied and unique as murder, piracy, mutiny, hijacking, and desertion in the face of the enemy. My brothers Stewart and White, asserting reliance on a more limited rationale, the reluctance of judges and juries actually to impose the death penalty in a majority of capital cases, join in the judgments in these cases. Whatever its precise rationale, today's holding necessarily brings into sharp relief the fundamental question of the role of judicial review in a democratic society. How can government by the elected representatives of the people coexist with the power of the federal judiciary, whose members are constitutionally insulated from responsiveness to the popular will to declare invalid laws duly enacted by the popular branches of government? The answer, of course, is found in Hamilton's Federalist Paper number 78, and in Chief Justice Marshall's classic opinion in Marbury v. Madison. An oft-told story since then, it bears summarization once more. Sovereignty resides ultimately in the people as a whole, and by adopting through their states a written constitution for the nation, and subsequently adding amendments to that instrument, they have both granted certain powers to the national government and denied other powers to the national and the state governments. Courts are exercising no more than the judicial function conferred upon them by Article 3 of the Constitution when they assess, in a case before them, whether or not a particular legislative enactment is within the authority granted by the Constitution to the enacting body, and whether it runs afoul of some limitation placed by the Constitution on the authority of that body. For the theory is that the people themselves have spoken in the Constitution, and therefore its commands are superior to the commands of the legislature, which is merely an agent for the people. The Founding Fathers thus wisely sought to have the best of both worlds, the undeniable benefits of both democratic self-government and individual rights protected against possible excesses of that form of government. The courts, in cases properly before them, have been entrusted under the Constitution with the last word, short of constitutional amendment, as to whether a law passed by the legislature conforms to the Constitution. But just because courts in general, and this court in particular, do have the last word, the admonition of Mr. Justice Stone, dissenting in United States v. Butler, must be constantly borne in mind. While unconstitutional exercise of power by the executive and legislative branches of the government is subject to judicial restraint, the only check upon our exercise of power is our own sense of self-restraint. Rigorous attention to the limits of this court's authority is likewise enjoined because of the natural desire that beguiles judges, along with other human beings, into imposing their own views of goodness, truth, and justice upon others. Judges differ only in that they have the power, and if not the authority, to enforce their desires. This is doubtless why nearly 2 centuries of judicial precedent from this court counsel and counsel the sparing use of that power. The most expansive reading of the leading constitutional cases does not remotely suggest that this court has been granted a roving commission either by the Founding Fathers or by the framers of the 14th Amendment to strike down laws that are based upon notions of policy or morality suddenly found unacceptable by a majority of this court. The framers of the Constitution would doubtless have agreed with the great English political philosopher John Stuart Mill when he observed, "The disposition of mankind, whether as rulers or as fellow citizens, to impose their own opinions and inclinations as a rule of conduct on others, is so energetically supported by some of the best and by some of the worst feelings incident to human nature, that it is hardly ever kept under restraint by anything but want of power." A separate reason for deference to the legislative judgment is the consequence of human error on the part of the judiciary with respect to the constitutional issue before it. Human error there is bound to be, judges being men and women being what they are. But an error in mistakenly sustaining the constitutionality of a particular enactment while wrongfully depriving the individual of a right secured to him by the Constitution nonetheless does so by simply letting stand a duly enacted law of a democratically chosen legislative body. The error resulting from a mistaken upholding of an individual's constitutional claim against the validity of a legislative enactment is a good deal more serious. For the result in such a case is not to leave standing a law duly enacted by a representative assembly, but to impose upon the nation the judicial fiat of a majority of a court of judges whose connection with the popular will is remote at best. The task of judging constitutional cases imposed by Article 3 cannot for this reason be avoided, but it must surely be approached with the deepest humility and genuine deference to legislative judgment. Today's decision is to invalidate capital punishment is, I respectfully submit, significantly lacking in those attributes. For the reasons well stated in the opinions of the Chief Justice, Mr. Justice Blackmun, and Mr. Justice Powell, I conclude that this decision holding unconstitutional capital punishment is not an act of judgment, but rather an act of will. It completely ignores the strictures of Mr. Justice Holmes, writing more than 40 years ago in Baldwin v. Missouri. I have not yet adequately expressed the more than anxiety that I feel at the ever-increasing scope given to the 14th Amendment in cutting down what I believe to be constitutional rights of the states. As the decisions now stand, I see hardly any limit but the sky to the invalidating of those rights if they happen to strike a majority of this court as for any reason undesirable. I cannot believe that the amendment was intended to give us carte blanche to embody our economic or moral beliefs in its prohibitions. Yet I can think of no narrower reason that seems to me to justify the present and the earlier decisions to which I have referred. Of course, the words due process of law, if taken in their literal meaning, have no application to this case, and while it is too late to deny that they have been given a much more extended and artificial signification, still we ought to remember the great caution shown by the Constitution in limiting the power of the states, and should be slow to construe the clause in the 14th Amendment as committing to the court, with no guide but the court's own discretion, the validity of whatever laws the states may pass. More than 20 years ago, Justice Jackson made a similar observation with respect to the court's restriction of the state in the enforcement of their own criminal laws. The use of the Due Process Clause to disable the states in protection of society from crime is quite as dangerous and delicate a use of federal judicial power as to use it to disable them from social or economic experimentation. If there can be said to be one dominant theme in the Constitution, perhaps more fully articulated in the Federalist Papers than in the instrument itself, it is the notion of checks and balances. The framers were well aware of the natural desire of office holders as well as others to seek to expand the scope and authority of their particular office at the expense of others. They sought to provide against success in such efforts by erecting adequate checks and balances in the form of grants of authority to each branch of the government in order to counteract and prevent usurpation on the part of the others. This philosophy of the framers is best described by one of the ablest and greatest of their number, James Madison in Federalist Number 51. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed. In the next place, oblige it to control itself. Madison's observation applies to the judicial branch with at least as much force as to the legislative and executive branches. While overreaching by the legislative and executive branches may result in the sacrifice of individual protections that the Constitution was designed to secure against action of the state, judicial overreaching may result in sacrifice of the equally important right of the people to govern themselves. The due process and equal protection clauses of the 14th Amendment were never intended to destroy the state's power to govern themselves. The very nature of judicial review, as pointed out by Justice Stone in his dissent in the Butler case, makes the courts the least subject to Madisonian check in the event that they shall, for the best of motives, expand judicial authority beyond the limits contemplated by the framers. It is for this reason that judicial self-restraint is surely an implied, if not an expressed, condition of the grant of authority of judicial review. The court's holding in these cases has been reached, I believe, in complete disregard for that implied condition. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and I'd be happy to take a look. Thank you.